Court records describe a collection of documents that many investigators once believed would remain buried for decades, sealed within legal filings, archived in federal systems, and scattered across civil lawsuits that most people would never read. Yet over time, portions of these records began to surface through court proceedings, document releases, and investigative reporting, slowly revealing fragments of a much larger story surrounding the financial figure Jeffrey Epstein, a man whose name would eventually become associated with one of the most scrutinized legal cases of the last 2 decades. And this is where the narrative becomes unsettling, because according to publicly released filings, the disturbing aspect of the Epstein documents is not contained in a single testimony or one isolated claim, but rather in the patterns that appear when thousands of pages are placed side by side. Patterns involving travel logs, legal agreements, redacted witness statements, and settlement records that span years and jurisdictions, forming a complex legal trail that investigators, journalists, and legal analysts have attempted to piece together piece by piece. According to court documents filed in multiple civil cases, Epstein's activities first drew the attention of law enforcement in the early 2000s, when allegations involving underage individuals began appearing in police reports in Florida. Public records indicate that the investigation expanded quickly, drawing in local authorities, federal prosecutors, and later civil attorneys, representing individuals who filed lawsuits describing encounters that they said occurred at several properties connected to Epstein. However, the disturbing part of the story does not simply lie in the allegations themselves, which were later addressed in legal proceedings and settlements, but in the structural details surrounding how the case moved through the legal system. In 2008, Epstein entered into what court filings describe as a non-prosecution agreement with federal prosecutors in Florida. According to publicly available records, this agreement allowed him to plead guilty to state charges while avoiding potential federal prosecution that had been under consideration at the time. Legal scholars and journalists later analyzed the unusual nature of this agreement, noting that it included provisions affecting potential co-conspirators, language that would later become the subject of intense legal scrutiny. But this is where the documents begin to raise deeper questions, because many of the details contained within that agreement remained sealed for years, hidden from public view. Do you want to know the truth behind the Epstein case? The darkest, most shocking secrets that the powerful don't want you to know? Then you need to follow this channel right now. Click the subscribe button and turn on the notification bell, because what we're about to reveal will shake the very foundations of power, and you can't miss a single detail. Prepare yourself for a journey into the depths of depravity and corruption, and join us in this fight for justice. Subscribe now. And this is where the files become interesting. When civil lawsuits began to move through federal courts years later, attorneys on both sides requested access to records that had previously remained sealed. What followed was a slow legal battle over transparency, redactions, and public access to documents. According to federal court rulings, thousands of pages connected to the case were gradually reviewed to determine what could legally be released. Many of those pages were heavily redacted with names, locations, and identifying information blacked out. Entire paragraphs were covered in black ink. Pages appeared where entire sections were missing. Lines of testimony stopped abruptly. Public records indicate that these redactions were implemented for legal and privacy reasons, including the protection of individuals who were not charged with crimes, because being mentioned in documents does not imply wrongdoing. However, the presence of these redactions created another layer of mystery surrounding what the files actually contained, and more importantly, what remained hidden. And this is where the pattern begins to emerge. According to flight records introduced during court proceedings and later discussed in investigative reports, Epstein maintained a private aircraft that traveled frequently between several properties connected to him. These logs listed passengers, destinations, and dates over multiple years. Some names appearing in these records were later discussed publicly during civil litigation, though legal experts consistently note that appearing in a flight log does not indicate criminal activity. Still, the existence of these travel records added another dimension to the investigation, expanding the scope far beyond a single location. But this is where the documents shift again, because according to testimony referenced in several lawsuits, individuals described not only travel, but also the structure of Epstein's operations, including staff roles, recruitment methods, and financial arrangements. Many of these statements were given under oath during depositions connected to civil cases. And while allegations referenced in filings are not proof of wrongdoing unless proven in court, the consistency of certain details across multiple testimonies became a central focus for investigators. Different witnesses, different years, similar descriptions. And that raised difficult questions. How had this network operated for so long without broader intervention from authorities? Why had early warnings not triggered larger investigations sooner? And why had so many documents remained sealed for years? The answers, according to legal analysts, may lie in the complex intersection of civil litigation, confidentiality agreements, jurisdictional limits, and prosecutorial discretion. The Epstein Files reveal how legal systems sometimes move slowly, especially when cases involve multiple jurisdictions, powerful financial interests, and extensive legal resources. State court records show that lawsuits connected to Epstein continued for more than a decade, with new documents appearing periodically as judges reviewed motions to unseal records. But the most disturbing element may not be a single document. It may be the timeline. Because when the documents are placed in chronological order, a different picture begins to form. Early complaints appearing in local police reports, followed by negotiations between attorneys and prosecutors, followed by settlement agreements, followed by sealed filings, followed by renewed civil litigation years later, each stage leaving behind documents that only became visible long after the events themselves. And this is where the scale becomes clearer. Investigative reporting based on court documents eventually revealed that Epstein owned multiple properties across the United States and abroad, including residences in Florida, New York, New Mexico, and the Caribbean, according to public records. Some of the allegations referenced in lawsuits described events at more than one location. Again, being mentioned in such filings does not imply guilt for any individual named, but the geographic spread of the documents expanded the investigation far beyond a single jurisdiction, which created another complication because different jurisdictions operate under different legal frameworks, different prosecutors, different courts, different evidence standards. And when cases cross those boundaries, our coordination becomes difficult. This is where many analysts believe the Epstein files become most disturbing, not because of any one accusation, but because of what the documents reveal about systemic complexity. The legal system, built to handle individual cases, often struggles when confronted with networks, influence, and international movement. But even that is only part of the story. Because according to court filings released years later, additional documents existed that had not been fully disclosed to the public. Judges reviewing the records acknowledged that certain materials remained sealed due to ongoing legal considerations, privacy concerns, or the involvement of individuals who had not been charged with crimes. And once again, the same phrase appears repeatedly in legal analysis: redacted, sealed, withheld. Which leads to a larger question. If thousands of pages have already been released, how many more pages remain unseen? And what exactly do they contain? Because when journalists began reviewing the newly unsealed portions of the files, they noticed something that investigators had suspected for years. The documents did not simply describe isolated events. They described systems, logistics, schedules, travel routes, legal negotiations, and internal communications that suggested a far more complicated structure than originally understood. And this is where the narrative shifts again, because once the documents began to surface, attention turned not only to what they revealed about Epstein himself, who was later charged federally in 2019 and died in custody while awaiting trial, but also to the institutions that had interacted with the case over the years. Prosecutors, law enforcement agencies, courts, financial institutions, and private legal teams all appeared within the documentary timeline. Not as villains, not as conspirators, but as components of a complex system navigating an extraordinarily complicated case. And this is the point where the Epstein Files stop being just a criminal investigation. They become a structural question. How information moves through legal systems. How cases evolve over time. How records are sealed, unsealed, negotiated, and redacted. And how long it can take before the public sees the full picture. But this is where the documents become even more unsettling, because several investigative journalists who reviewed the released files noted that some of the most referenced materials in testimony were not actually present in the documents made public. Witnesses referred to communications, internal schedules, and other records that have never appeared in any official release, which raises another quiet but persistent question. What else exists within the Epstein archive? And more importantly, who decides when the public gets to see it? As more documents slowly entered the public record through court orders and investigative reporting, the focus of the Epstein files began to shift. The discussion was no longer centered only on the original criminal case, but on the structure of the documents themselves, the timelines they revealed, and the legal pathways through which information had been sealed for years. According to publicly released filings, attorneys involved in related civil lawsuits pushed repeatedly for additional records to be unsealed, arguing that the documents could help clarify the scope of events connected to the case. Judges reviewing these requests often had to balance transparency with legal protections because many individuals referenced in the filings had never been charged with crimes, and being mentioned in documents does not imply wrongdoing. But this is where the pattern becomes more complex. When journalists and legal analysts began examining the documents that were eventually released, they noticed that certain details appeared repeatedly across different filings. References to travel schedules, staff roles, and communications between attorneys appeared across multiple years of litigation. According to court records, some of these details were discussed during sworn depositions connected to civil cases, meaning the statements were made under oath. Still, many of the transcripts released to the public contained heavy redactions, entire names removed, locations hidden, and sections of testimony blacked out for legal reasons. And this is where the documents raise another quiet question. If large portions of testimony were redacted before public release, how much context remains unseen? Investigators reviewing the files often point out that the Epstein archive is not a single document, but a network of legal records spread across federal courts, civil litigation, police reports, and financial filings. When placed together, they form a fragmented picture of a case that moved through the legal system over many years. But perhaps the most unusual detail referenced in public records is the scale of the documentation itself. Thousands of pages connected to depositions, settlements, and motions to seal or unseal evidence exist within court archives. Some of these materials were only released after extended legal challenges by media organizations requesting public access. And even then, judges noted in their rulings that certain information would remain withheld to protect privacy or ongoing legal considerations, which leads to a deeper structural issue revealed by the files. The Epstein case shows how legal records can remain sealed for long periods, sometimes decades, depending on how courts rule on confidentiality agreements and privacy protections. And while many pages have now entered the public domain, legal experts believe additional documents connected to the case may still remain sealed within court archives. And that is where the story becomes more complicated, because the disturbing element of the Epstein files may not be contained in what has already been released, but in the uncertainty surrounding what has not yet been made public. As the timeline of the Epstein files continued to unfold through court proceedings, investigative journalism, and the gradual unsealing of documents, the broader structure of the case became clearer. Not through a single revelation, but through years of records slowly entering the public domain. According to court documents and federal filings, the legal story surrounding Jeffrey Epstein stretches across decades, multiple jurisdictions, and numerous civil lawsuits that attempted to reconstruct events described by individuals who later came forward in legal complaints. Are you shocked by what we've uncovered so far? Well, that's just the tip of the iceberg. There's so much more to come. More powerful names, more sinister schemes, more silenced victims. If you want to be on the front lines of this investigation, you need to subscribe to this channel now. Leave your comment below and tell us what you think. Your voice is crucial in this fight. The more we unite, the stronger our call for accountability will be. So subscribe, comment, and share. The truth depends on it. Public records indicate that the first major law enforcement investigation connected to Epstein began in Florida in the early 2000s, after reports were made to local authorities. According to police documents referenced in later court proceedings, our investigators began collecting statements and evidence that eventually led to a criminal case. In 2008, Epstein pleaded guilty in Florida State Court to charges related to solicitation of a minor and solicitation of prostitution, resulting in a jail sentence and registration as a sex offender. This remains the only criminal conviction directly tied to the earlier investigation. However, this is where the legal structure surrounding the case became widely debated. According to publicly released filings, the 2008 plea agreement reached between Epstein and federal prosecutors included provisions that prevented federal charges from moving forward at that time. The agreement later became the subject of extensive legal scrutiny, with critics arguing that it had shielded potential co-conspirators from prosecution. Federal courts would later examine aspects of that agreement in separate legal proceedings, including lawsuits filed by individuals who argued they had not been properly informed during the negotiation process. But the story did not end there. Years later, civil lawsuits began to reveal additional details through depositions, testimony, and financial records introduced during litigation. According to publicly released court transcripts, several witnesses described interactions connected to Epstein's residences and travel activities. Again, legal experts consistently emphasize that individuals mentioned in civil filings are not automatically accused of wrongdoing, and references in documents do not imply guilt. Nevertheless, the testimonies added new layers to the overall picture presented in the files. One element that drew particular attention during these legal proceedings was a set of flight logs associated with Epstein's private aircraft. According to records referenced in court filings and later discussed in media investigations, these logs documented numerous flights between properties connected to Epstein, including locations in Florida, New York, New Mexico, and the Caribbean. The documents listed passengers and travel dates over several years. Again, legal analysts stress that appearing in a flight log does not indicate involvement in criminal conduct. But the records became an important part of the broader investigative timeline. Another major component of the Epstein files emerged through a civil defamation lawsuit involving Ghislaine Maxwell and Virginia Giuffre. During that case, attorneys sought access to deposition transcripts and other records that had previously been sealed. Federal judges eventually ordered portions of those materials to be unsealed, releasing thousands of pages of testimony and evidence to the public. Many of these documents contained extensive redactions, with names and identifying details removed to protect privacy or comply with court rulings. In 2019, the case entered a new phase when federal prosecutors in New York charged Epstein with sex trafficking of minors and conspiracy to commit sex trafficking. According to the indictment, the charges related to alleged conduct between 2002 and 2005 involving individuals under the age of 18. Epstein was arrested in July 2019 and held in federal custody while awaiting trial. But the case took another dramatic turn. In August 2019, Epstein was found unresponsive in his cell at the Metropolitan Correctional Center in New York. The official investigation conducted by the New York City Medical Examiner ruled the death a suicide. The event triggered extensive public discussion and further scrutiny of the broader case. So particularly because Epstein's death meant the criminal trial would never take place. However, the legal proceedings connected to the Epstein files did not stop there. In 2021, Ghislaine Maxwell was tried in federal court in New York on charges related to trafficking and conspiracy. After a multi-week trial, a jury convicted Maxwell on several counts, including conspiracy to transport minors for illegal sexual activity. She was later sentenced to federal prison, and this conviction remains the most significant criminal outcome connected to the broader investigation following Epstein's death. Meanwhile, civil litigation connected to the case continued in multiple courts. Several lawsuits were filed against financial institutions alleging failures in oversight connected to Epstein's accounts. Some of these cases resulted in settlements without admissions of wrongdoing, according to legal filings. And the purpose of these civil suits was to address claims brought by individuals seeking compensation and accountability through the legal system. But the most unusual part of the Epstein files remains the documents themselves. Thousands of pages, depositions, court motions, travel logs, financial records, witness statements, legal agreements. Many of these documents became public only after long legal battles over transparency. Even today, analysts note that some materials referenced in testimony remain partially redacted or sealed due to privacy protections or court rulings. And that leaves a lingering question surrounding the Epstein archive. Because while the files reveal a timeline of investigations, lawsuits, and legal proceedings that stretched across more than 2 decades, they also demonstrate how complex cases involving wealth, international travel, and multiple jurisdictions can move slowly through the legal system. Information appears gradually, sometimes years after events occur, as courts review requests to release records. So when people ask what the Epstein files actually show, the answer is both simpler and more complicated than expected. They show a documented legal history, a series of investigations, a criminal conviction in 2008, federal charges filed in 2019, a trial and conviction of Ghislaine Maxwell in 2021, and thousands of pages of records that continue to be analyzed by journalists, attorneys, and researchers trying to understand the full scope of what happened. But perhaps the most persistent question raised by the Epstein Files is not about a single person or a single event. It is about transparency, about how long critical documents can remain hidden, about how legal systems balance privacy, due process, and public accountability. Because even after years of document releases, redacted pages and sealed records still appear within the archive. And the final unanswered question remains quietly present in the background of the entire case. If this many details only emerged after years of litigation and document releases, how much of the full story has the public actually seen? In the end, the Epstein Files do not read like a single story. They read like an archive, scattered across years of court records, depositions, sealed motions, and slowly released documents that only began forming a clearer timeline long after many of the events had already passed. According to public records, the case involved local investigations, federal charges, civil lawsuits, financial settlements, and one major criminal conviction in 2008, followed years later by the federal prosecution and conviction of Ghislaine Maxwell in 2021. Yet even after thousands of pages were reviewed and partially unsealed, large portions of the record remain redacted or sealed due to legal and privacy protections. And courts have repeatedly noted that being mentioned in documents does not imply wrongdoing. But this is where the broader meaning of the Epstein Files emerges, not simply as a case about one individual, but as a rare window into how complex legal systems handle allegations, settlements, sealed records, and jurisdictional limits over long periods of time. Investigators, journalists, and legal scholars continue examining these documents not only to understand what happened, but also to understand how information moves through institutions. Because the most disturbing element of the Epstein Files may not be contained in a single testimony or a single name. It may be the structure that allowed so much of the story to remain hidden for so long. And the final question that continues to follow the documents is a simple one. In systems built on transparency and public accountability, who ultimately decides when the full record becomes visible? You've made it this far. You've seen how deep the rabbit hole goes, how vast the webs of complicity are. Now you have a choice. You can turn your back and pretend none of this happened, or you can join us. Subscribe to this channel, hit the like button, leave your comment, and most importantly, share this video. Because the only way to defeat the darkness is to bring it into the light. The more people see, the harder it will be for the predators to hide. Together we can build an unstoppable movement for justice. But it starts with you, with your voice, your dedication, your click on that subscribe button. Let's make this echo in the halls of power. Let's shake the foundations of the mighty. Let's show the entire world what truth can do. But only if you join us now. Subscribe, act, and let's change history together.